Okay, so good evening, everyone. It's a pleasure to welcome you all again for the 30-hour certificate course on drafting, pleading, and conveyancing, organized by School of Law, Fairfield Institute of Management and Technology, in association with Pro Bono Club. Today, we have with us our esteemed speaker for Module 4 on civil pleadings, Mr. Harsh Tikoo. Mr. Harsh is an established advocate practicing in Supreme Court, Delhi and Rajasthan High Court, and other trial courts. He is on the panel of various companies and deals with cases of DRT, recovery, check dishonor, and consumer disputes, as well as civil panel of Delhi State Legal Service Authority, Delhi Government. He has also authored an exhaustive, analytical, and incisive book on law of protection of children from sexual offences, published by Bharat Law Publication. Welcome, sir. It's a pleasure to have you with us today.
Thank you. Thank you, everyone. I hope I'm audible now.
You are perfectly audible, and you can share your screen if you want to, or you can switch on your camera, whatever is feasible for you.
Is it visible?
Yes, sir, it's visible.
Hello, everyone.
Hello, sir.
So I'm told that, and also I'm aware since you all people have already cleared your LLB. So topic is civil pleadings here. I don't want to go much into historical and theoretical aspect of civil pleadings since it would consume unnecessary time and you all people can read it on your own. So I will try to deal with the practical aspects of civil pleadings and how does it affect court proceedings? Why is it necessary? And what is its relevance? There are, and as we already must be knowing, or those who don't know must know, that civil litigation comprises of significant majority part of litigation in this country. In fact, whatever we see, most of the times these are of civil offenses or suits or writ petitions or damages, tax litigation, SLPs. Most of these things are civil nature, and rest of it is of criminal nature. Civil litigation starts from court of first instance, which is civil courts, and it goes on to the extent of special leave petition in the Honorable Supreme Court. And beginning with civil court, there are things which we need to take care of, and there are things which we should always keep in mind while going ahead with our cases. I will share a few cases where I was involved, and I will try to show you that what happens generally when we try to miss out something or when we ultimately draft something which is quite good. So here, I asked everyone to carry CPC, Code of Civil Procedure, with you. I hope you people are carrying it yourselves. Civil, sorry. Civil litigation, civil pleadings, as this topic suggests, civil pleadings foremostly covers civil proceedings in the trial courts. And trial court, by trial court, I mean court of first instance, and it is usually dependent upon what is jurisdiction of respective court. If you're generally it's civil judge or senior civil judge, where suit actually lies. There are various facets. Why do we insist upon proper pleading? Basically to cull out issues where parties are in dispute. And once issues are decided, only then court can proceed and evidences can be tendered in the court. Once issues are not decided or issues are uncertain, then ultimately judgment would also be uncertain and parties would be aggrieved. That whole exercise would be futility. So ultimately, to cull out proper issues where parties are not agreeing with each other, pleadings are required. Pleadings are also required ultimately to narrow down whole controversy. Suppose you have a grievance against your tenant that that person should be evicted from your property. You also have grievance that that person has not paid you rent of last 4 months. And at the same time, you have also grievance that that person has destructed something of your property. You have three grievances. But you might choose to file suit in regard to pendency of rent only. And you might forego everything else. Once you don't file your case in regard to other two allegation as well, then you would be stopped to raise those questions in future as well because of order 2 rule 2 of CPC, which says that all connected matters should be clubbed together. If they are not clubbed together, you would be stopped to raise it again because multiple litigation is always seen not with good eye by the courts. So this is why you need to be thoroughly clear that what do you want from the court and how do you want that particular issue to be addressed by the court. Once you will raise all those questions before the court and then only court will decide. In earlier times, there used to be limitation of one issue only in every case. After that, situation changed and now multiple issues can be raised in one case. It used to happen in colonial times when only one issue was allowed to be raised by the party. But now, since we have Code of Civil Procedure, and we can raise as many issues as you want until it's restricted to one cause of action. Now, coming to the litigation part, Order 6, Order 7, Order 8 of Code of Civil Procedure is very important for the purpose of pleadings. I hope you people are carrying with yourself, and especially you should open Order 6 of the Code of Civil Procedure. Order 6 is pleadings generally. And pleadings shall mean plaint or written statement. I'm sharing copy of a plaint. It's an eviction suit. Is it visible?
No, sir, it's not visible. Are you trying to share screen?
Yes, yes.
Okay. No, screen is not visible.
Wait a minute, I'm trying to.
Yeah.
I can remove access mode. Swati, would it be possible for you to share it?
Yes, definitely. You send whatever file you want me to share, I will share on my screen.
I have shared it with you.
Okay,
Open page 36 of this PDF file.
definitely. Page number 36.
36 of PDF file.
Okay. Yeah. Is it visible to everyone?
So this is suit of eviction. You people can see index. If this suit was filed in the court of first instance, which is original court. Now there are things to remember while drafting the suit. This is suit by a landlord against tenant. I am giving you very brief fact. It is a suit filed by landlord against alleged tenant. According to landlord, tenant is भगवान देवी and others. आप लोग अगर title देख सकते हो, there is plaintiff and there is defendant. It's bit blurred, I understand, but Kamlesh is plaintiff and Bhagwan Devi and others is they are defendants. So Kamlesh is landlord as per this suit and Bhagwan Devi उनकी टेनेंट है और उन्होंने भगवान देवी को अपना डिफेंडेंट बनाया इन सिविल प्रोसीडिंग जो केस फाइल करता है दैट पर्सन इज नोन एज प्लेंटिफ एंड अदर पार्टीज आर नोन एज डिफेंडेंट्स स्वाति इसमें आगे बढ़ना
Sure.
now it's memo of parties it's very crucial I will tell you why memo of parties generally carries name in detail with address of the plaintiff and defendant. Here, plaintiff is Shrimati Kamlesh, who has filed through her son, power of attorney holder, and she is landlord. And going further, versus down below, Shrimati Bhagwan Devi, she is tenant, और उसके बाद referent number 2 in this case is Shri Ramesh Kumar, who is another tenant. Both are related. And then ultimately, going down below, it ends here. In this case, order 1, if you people will open order 1, you people will see order 1 rule 8 and order 1 rule 10. I hope everyone can see it.
Yes, sir.
Order 1 rule 10 says, just a minute. Order 9 rule order 1 rule 9, misjoinder and non-joinder. No suit shall be defeated by reason of the misjoinder or non-joinder of parties. Here, I am saying Kamlesh ने भगवान देवी के अगेंस्ट केस फाइल किया है. भगवान देवी इज टेनेंट, बट अगर भगवान देवी टेनेंट नहीं भी है, एज पर दी फैक्ट्स, उसने रेंडमली केस फाइल कर दिया भगवान देवी के अगेंस्ट टू प्रूव समथिंग, पर भगवान देवी टेनेंट नहीं है, तो क्या इस रीजन से केस डिफीट हो सकता है? नो. सो you can make anyone or your party because there is a concept of dominus litis which says plaintiff is owner of his own case and only plaintiff will take care of it. Plaintiff की मर्जी है, वो जिसको पार्टी बनाना चाहता है बना सकता है. So plaintiff made भगवान देवी as party. Whatever would be the result, only plaintiff will face the consequences. So court does not go into these things कि आप लोगों ने पार्टी किसी को भी बना दिया, actually tenant वो था, मेरे को क्यों पार्टी बनाया. It does not, court is not concerned with that because plaintiff has chosen to do this, plaintiff will bear the consequences. So order 9 says misjoinder and non-joinder के कारण कोई suit defeat नहीं होगा. You people can read it very well. And these are essential aspect of the suit because you need to add parties first. Order 1 rule 10 says suit in name of wrong plaintiff where a suit has been instituted in the name of wrong person as plaintiff, or where it is doubtful whether it has been instituted in the name of right plaintiff, court may any stage of the suit, it is necessary determination real matter or dispute to order any person to be substituted. So plaintiff, अगर plaintiff गलत है तो वो suit dismiss हो जाएगा. So plaintiff should be relevant person but not the defendant. And court may strike out or add parties, that is part 2. So memo of parties is relevant for the purpose of suit drafting, which is the foremost and first thing. It should be correct and order. अगर आपका डिफेंडेंट आप करेक्ट नहीं बना रहे हो तो अल्टीमेट जो रिलीफ मिलेगा वो आपको बेनिफिट नहीं करेगा. और अगर डिफेंडेंट ये कहता है कि मेरे को इस सूट के अंदर पार्ट नहीं होना था, किसी और को होना था, तो कोर्ट कहेगा कि इट डजंट मैटर, अल्टीमेटली प्लेंटिफ विल बियर द consequences. तो किस पार्टी के अगेंस्ट आपका डिस्प्यूट है, it is very important to know, and it is very important while drafting the plaint. Going further, इसके बाद स्वाति इसके नीचे आना. There is,
सर इसमें एक डाउट था
बताइए.
सर, अगर गलत डिफेंडेंट बना दिया है तो फिर अब क्या होगा फिर?
सपोज करो मेरा आपके फ्रेंड से डिस्प्यूट है, बट मैंने आपको पार्टी बना दिया. मेरे को 50,000 रुपए लेने हैं आपके फ्रेंड से, बट मैंने आपको पार्टी बना दिया, और वो केस समहाउ मैं जीत भी जाता हूँ, क्योंकि आप कोर्ट में नहीं आओगे, आपको परवाह ही नहीं है कि, क्योंकि अल्टीमेटली आपने मेरे से तो लिए नहीं है पैसे, तो आप कोर्ट भी नहीं आओगे, एंड मैं केस जीत भी जाऊंगा. फिर मैं एग्जीक्यूशन में जाऊंगा कि भाई मेरे फेवर में डिग्री पास हुई है, तो उस पर्सन को बोलो कि पैसे पेमेंट करे. और आप एग्जीक्यूशन डिग्री के अंदर आके बोलोगे कि मेरे को तो कभी इसने पैसे भी नहीं दिए, और मैं इसकी कोई मेरे साथ एग्रीमेंट नहीं है, मेरे साथ कोई ट्रांजेक्शन नहीं है, एंड देयर इज नो अदर थिंग विच प्रूव दैट वी पीपल हैड ट्रांजेक्शन और एनी एविडेंस. तो उस बेसिस पे यू कैन इंटरवीन एट द टाइम ऑफ एग्जीक्यूशन, एंड कोर्ट विल से दिस डिग्री कांट बी एग्जीक्यूटेड. You can't be compelled to pay 50,000 rupees. It was my mistake that I made you party when I should have made your friend party in the suit, because your friend had actually taken money. Are you getting me? Basically, civil remedy जो होती है, it is called, except four type of cases, civil cases are right in persona. जो दो जने लड़ रहे हैं केस के अंदर, कोर्ट सिर्फ उन दोनों का राइट डिसाइड कर रहा है, किसी वो डिग्री किसी थर्ड पार्टी के ऊपर एप्लीकेबल नहीं होती. सो अगर मैं किसी गलत पर्सन को केस के अंदर पार्टी बना रहा हूं, तो अल्टीमेटली उसके कंसिक्वेंसेस मेरे को फेस करने पड़ेंगे. या तो वो केस में जीत ही नहीं पाऊंगा, पहली बात तो, अगर मैंने तुमको पार्टी बना दिया तो पॉसिबली मेरे पास एविडेंस ही नहीं होगा टू प्रूव दैट वी पीपल हैड ट्रांजेक्शन, तो मेरा सूट वहीं डिसमिस हो जाएगा. बट वो सूट इसलिए डिसमिस नहीं होगा कि मैंने तुमको पार्टी बनाया, सिर्फ इस कारण से डिसमिस नहीं होगा वो, तुम आके कहोगे कोर्ट में कि मेरे से तो कोई ट्रांजैक्शन ही नहीं थी, इसने मेरे को गलत पार्टी बना दिया, तो कोर्ट विल से दैट वी विल सी इट बाय वे ऑफ एविडेंस ओनली. अगर आप गलत भी पार्टी बने हो तो मैं अपना केस बाय वे ऑफ एविडेंस प्रूव नहीं कर पाऊंगा, और यू विल हैव एडवांटेज अल्टीमेटली टू हैव डिग्री इन योर फेवर. बट कोर्ट
तो,
सिर्फ इस कारण से सूट
तो
डिसमिस.
सर एक तरीके से तो सूट डिफीट ही हो गया ना उसमें, अगर एक पावर दी जाए कि जो एक्चुअल में डिफेंडेंट है उसको उसका नाम लिखने की पावर दी जाए
उस
प्लेंटिफ को. एक
प्लेंटिफ ने अपनी मर्जी से डिफेंडेंट का नाम लिख लिया, मैंने लिख लिया तुम्हारा.
गलती सुधारने का एक मतलब उसमें प्रोविजन रहती है.
यस यस यस. नाउ गलती सुधारने की तुमने बात करी, सब्स्टिट्यूशन ऑफ डिफेंडेंट, देयर आर वेरियस ऑप्शंस. सबसे ज्यादा जो यूज होता है सिविल लिटिगेशन के अंदर, इट इज ऑर्डर 6 रूल 17. आप लोग देखोगे ऑर्डर 6 रूल 17, इट इज सब्स्टिट्यूशन ऑफ, इट इज अमेंडमेंट ऑफ प्लीडिंग्स. ऑर्डर 6 रूल 17 आप खोलोगे, और इनफैक्ट ऑर्डर 1 रूल 10 भी अगर आपने ऑलरेडी खोल रखा है, इसको भी अगर आप पढ़ोगे तो इसमें लिखा हुआ है सबसेक्शन 2 रूल 10 सब रूल 2, कोर्ट में स्ट्राइक आउट और एड पार्टीज. अगर आप लोगों को दिख रहा है, कोर्ट में एट एनी स्टेज ऑफ द प्रोसीडिंग ईदर अपॉन और विदाउट द एप्लीकेशन ऑफ ईदर पार्टी and on such terms as may appear to the court to be just, order that the name of any party improperly joined. So अगर मैंने तुमको improperly join किया है तो उसको strike out कर देगा कोर्ट, और कोई और person जिसको who ought to have been joined, whether as plaintiff or defendant, whose presence before the court may be necessary, उसको court as a defendant add कर देगा. So order 1 rule 10 is important to know that who should be party and who should not be. Is it clear?
यस सर।
आप ऑर्डर 1 रूल 10 आपने देख लिया ना?
यस सर, मैं एक बार फर्दर रीड कर लूंगा क्लास के बाद। बाकी कोर्ट के
Court
पास
out
मतलब खबर रहती है काफी इसमें।
order 1 rule 10, just remember this. Going further, in the Honorable Court of Senior Civil Judge T. Hazari Court. Now in Delhi, I don't know if you people already know this, there is concept and it varies from state to state. In Delhi, if you are filing a suit, suppose say for the recovery of or your cause of action is worth around 3 lakh rupees, then your suit would lie before the civil judge. If it is more than 3 lakh rupees, but till 20 lakh rupees only, it would lie before the senior civil judge. But if it is going beyond that, from 20 lakh till 2 crore rupees, if value of your suit is till 2 crore rupees, whether you are seeking recovery of money for 50 lakh, 60 lakh, 1 crore, or you are filing a case for the declaration of the property whose value, which that property is valued around 50 lakh, 1 crore, 2 crore, those suits will lie before the district judge. Above 20 lakh till 2 crore rupees, and then from 3 lakh to 20 lakh before the senior civil judge, and then till 3 lakh it would be before civil judge only. These are hierarchies of the civil judges on the civil side. So this suit is filed before the senior civil judge. Title of this suit is Suit for Possession, Recovery of Arrears of Rent rupees 4,000 and damages at rupees 12,000 per month, along with interest at the rate of certain percentage. Now what happened in the suit, this as I earlier submitted, उन्होंने भगवान देवी को अपना टेनेंट बनाया, और इस सूट के अंदर आप देखोगे स्वाति इसमें थोड़ा सा और आगे बढ़ना, these are pleading part which generally begins with this only. Now pleading needs to carry material fact. People are of this view generally, they repeatedly mention law point. Law point should be avoided in the pleadings, but only and only material fact needs to be mentioned in the pleadings. You will find the same thing in Order 6 and Order 7 of the Code of Civil Procedure. Wait a minute. Sir. ऑर्डर 7 आप सब लोग एक बार ओपन कर लेना सीपीसी के अंदर। particulars, order 7, rule 1. It says particulars to be contained in plaint. Plaint shall contain following particulars. If you people have already having CPC with you, you can see it. Order 7, rule 1. One states name of the court in which suit is brought. So we have already shared you with this plaint in the 30,000 court, senior civil judge. It was name of the court which was mentioned first. Order 7, rule 1 states this. Then B, the name, description, and place of residence of the plaintiff. We shared memo of parties with you already. It reflected name, description, and place of the residence of the plaintiff. Then C, order 7, rule C, name, description, and place of residence of the defendant, so far as they can be ascertained, because sometimes I might make someone a party, but I might not be able to ascertain their exact address. In those situations, I will mention their name, but I would be precluded to mention exact address of defendant. This is why C says this. D, where the plaintiff or defendant is a minor or a person of unsound mind, a statement to that effect, because minor, in India, minor till age of 18 can't be appeared or can't be represented in the court directly, but through guardian only. So that needs to be mentioned. If someone is appearing through guardian, then the guardian's name would be appearing, that this minor is appearing through certain guardian, whatever that name would be. After that, the fact constituting the cause of action and when it arose. So after writing suit for possession recovery of arrears of rent as it is reflected on the screen, material facts will begin. Here the case is plaintiff is a peace-loving address. This stated in memo of parties. Plaintiff is, in paragraph 2 it is mentioned, plaintiff is aged about 55 years. Her health is not up to the mark and most of the time she remains ill. Hence she executed a special power of attorney in name of her son. Now paragraph 3 states plaintiff is one of the owner, landlord of the property bearing number this. Because this is suit for the eviction, it is necessary to mention that you are owner or landlord. It could be an eviction suit by the tenant against subtenant as well. So it needs to be mentioned before the court that who are you and why are you filing this suit. So this person, plaintiff here, mentioned that I am the owner, landlord of the property bearing number this, and it has also clearly specified that title is not disputed, that person is plaintiff owner, plaintiff is the only owner person. Then comes story, which is again factual part in paragraph number 4, and it contains that the shop bearing number this was let out to Mr. Achal Prasad Gupta during his lifetime in the year 1992 at the monthly rent of 500 rupees, excluding electricity, etc., etc. So these are material facts which are going on. I will come on this too later, but the facts constituting the cause of action is this. It is going on further. After that, in last, Swati, इसमें एक या 2 पेज आगे बढ़ना और बस
You want an extra?
ऊपर नहीं not annexures, but इसके नीचे B or next page. Bus. Now, if you can see order 7 rule 1, after facts constituting the cause of action and when it arose, in F it is mentioned facts showing that the court has jurisdiction. So I have written in paragraph number 22, the plaintiff has written in paragraph number 22 that the cause of action for the filing of the present suit arose in favor of the plaintiff against the defendant. After culling out all the material facts till paragraph number 21, in paragraph number 22 as per order 7 strictly, we have mentioned that cause of action arose first time on this date when the plaintiff got issued legal notice and terminated the tenancy and asked the defendant for vacating the shop in question. It is very important to mention specifically what is cause of action. If you are missing out to mention this particular fact, then ultimately you are missing out to state that by what particular fact you are actually aggrieved. In this case, plaintiff was aggrieved that because of this notice, legal notice on this particular date was intimated to the defendant, but defendant did not comply. Defendant did not ultimately vacate the shop within 15 days of the receiving of the notice. This is why it needs to mention for the court as well that on this particular day cause of action arose. Now, why is it necessary? Because Limitation Act says that every suit, although different time is prescribed for different causes of actions, but generally 3 years. So every suit needs to be filed within 3 years of this cause of action. Here, this cause of action arose on 11th December 2013 when the plaintiff got the legal notice. So time started from 11th August 2013. Suppose plaintiff does not choose to file suit, although cause of action arose, but plaintiff did not choose to file a suit. Then after 3 years, his remedy would be barred. He won't be able to avail anything. After this particular paragraph, comes the prayer part. In this case, there was no set off as shared in Order 7 Rule 1, so I will tell it from different pleading. Prayer part is important. Honorable Supreme Court has held it in so many cases that you won't be granted any benefit which you have not asked for. Your prayer must be thoroughly drafted. What you are stating in your prayer will ultimately be granted by the court. If you are not praying the same thing, then it won't be granted by the court. So आपकी prayer बहुत carefully drafted होनी चाहिए. आपकी prayer destructive नहीं होनी चाहिए. आपकी prayer अगर कहीं से भी इस तरीके से casually drafted है, then ultimately it will defeat whole purpose of the suit. आप चाहे facts को बहुत अच्छे से mention करो, draft करो, but अगर आप उसके अंदर prayer clause को miss out कर रहे हो, then ultimately it will cost you immense. यहाँ पर pass a decree of possession in favor of the plaintiff and against the defendant. So मैंने कहा कि उसको defendant को property से निकालो बाहर और vacate किया जाए. उसके बाद B क्या है? Prayer B, स्वाति इसको scroll down करना. Pass a decree for recovery of 12,000 per month in respect of illegal possession of the suit property. हो सकता था मैं सिर्फ ए प्रेयर पर ही रिस्ट्रिक्ट रखता अपने आप को कि इसको वेकेट कर दो. कई लोग ये भी करते हैं कि इसको सिर्फ खाली करवा दो, मेरे को पैसा कुछ नहीं चाहिए. लेकिन अगर मैं मेंशन करूंगा कि मुझको रिकवरी 12,000 रुपए की रिकवरी हर महीने के हिसाब से दिए जाए, तभी वो प्रेयर मेरे को अवार्ड की जाएगी अगर मैं केस जीता हूं. अगर मैंने ये मिस आउट कर दिया, then it won't be granted in my favor. So your prayer clause is equally important like your material factual pleadings. If you are missing out something in your pleadings, आप अगर किसी fact को अपनी pleadings में mention नहीं कर रहे हो, again if you miss out there, then आप उसका issue भी future में frame नहीं करवा सकते. I will come on issue part as well. Now see Order 7 Rule 2. It says in money suits, where the plaintiff seeks recovery of money, plaintiff shall state the precise amount claimed. हमने 12,000 रुपए यहाँ पर रिकवरी के मांगे हैं. I have precisely stated कि 12,000 रुपए होने चाहिए. I won't write casually कि any lump sum amount or any rough estimate, any approximate estimate. I won't be allowed to do that for again important reason. अगर मैं 12,000 रुपए मांग रहा हूं तो मैं कोर्ट फी दूंगा. कोर्ट फी मेरी उसी अमाउंट के अकॉर्डिंग दी जाएगी. यहाँ पे आपको प्रेयर बी में दिख रहा है, पास अ डिक्री फॉर रिकवरी ऑफ 4,000, रेंट ऑफ 8 months at rupees 500 per month from May 2013 to December 2013 along with interest. So everything has been computed in proper manner in terms of Order 7 Rule 2, because it is money suit as well, like it is eviction suit. So as per Order 7 Rule 2, it needs to be specifically mentioned, otherwise court won't entertain this as well. It should be clearly stated, other party would take the objection otherwise. Order 7 Rule 3 states where the subject matter of the suit is immovable property. In our case, subject matter of the suit is immovable property as well, because it's a eviction suit, an eviction suit. Where the subject matter of the suit is immovable property, the plaint shall contain a description of the property sufficient to identify it, and in such cases, property can be identified by boundaries or numbers in record of settlement or survey. Plaint shall specify his boundaries. Now हमने पैराग्राफ नंबर 3 और 4 देखा था हमारी प्लेंट का, उसके अंदर क्लियरली लिखा था दैट दिस प्लेंटिफ इज लैंडलॉर्ड. Paragraph number 3, plaintiff is one of the owner landlord of property bearing number R5 and 6, old R block, Khasra number this, exactly identified the property. Because again, it is essential aspect of drafting of the suit. Going further, when plaintiff sues as representative, where plaintiff sues in Order 7 Rule 4 it is mentioned, where the plaintiff sues in a representative character, plaintiff shall show not only that he has an actual existing interest in the subject matter, but that he has taken the steps if necessary to enable him to institute a suit concerning it. Here it was not representative, but this suit is filed by son of the woman, Kamlesh. So it is mentioned in paragraph number 1 that she is an old age lady. Paragraph number 2, sorry. Plaintiff is aged about 55 years, not up to mark, and most of the times she remains, hence she executed a special power of attorney in her elder son, namely Ramanjit. This is in compliance of Order 7, Rule 4. Now comes Order 7, Rule 5, that defendant's interest and liability to be shown. आपको अपनी प्लेंट में ये बताना है कि मेरा क्या है, उसके बाद दिखाना है कि डिफेंडेंट का इसमें क्या रोल है. Plaintiff shall show the defendant is यहीं पर रुकना स्वाति. 4. Order 7 Rule 5 कहता है plaintiff shall show the defendant is or claims to be interested in the subject matter and he is liable to be called upon to answer the plaintiff demand. तो डिफेंडेंट को क्यों बुलाया इस केस के अंदर, क्या किया है डिफेंडेंट ने ऐसा, तो वो पार्ट स्टार्ट होता है इस पैराग्राफ से, जिसमें कहते हैं कि भाई हमने जो प्रॉपर्टी इन क्वेश्चन है, वी गेव इट टू मिस्टर अचल प्रसाद गुप्ता, लेट हस्बैंड ऑफ डिफेंडेंट नंबर 1 ड्यूरिंग हिज लाइफ टाइम इन द 1992 एट द मंथली रेंट ऑफ दिस suit property shape in question is specifically shown red color in the site plan. Now paragraph number 5, it also states the tenancy was oral and tenancy commences from every first of the month and ends on the last day of the same month. Again, it is in regard to defendant that husband of the plaintiff expired on this date in paragraph number 6, his 2 sons, namely this and this, and then paragraph number 7, that after the death of the husband of the plaintiff, Mr. Achal Prasad Gupta admitted the plaintiff as his landlord and signed on the acknowledgement of rent receipt, copy of the last. So basically, defendant, who is no more now, Achal Prasad Gupta, admitted the plaintiff was landlord. तो basically मैं landlord हूँ, वो tenant है, उसने admit कर रखा है, और अब वो हमने उसको notice issue किया, अचल प्रसाद गुप्ता is no more, हमने उसकी wife को बाहर निकलने के लिए बोला, तो उसकी wife ने खाली करने से मना कर दिया. These are facts related to defendant. The defendant, why defendant should be called in this suit? What is actually issue according to plaintiff only? We are speaking of plaintiff side at this time, not the defendant side. 6th point says grounds of exemption from limitation law. As I stated before, that once we mention cause of action, which is generally mentioned in towards last side of every plaint, अगर हम वहां पर डिलेड है, हमारा कॉज ऑफ एक्शन 2012 में स्टार्ट हो गया, हमारे पास 3 साल का टाइम है, अगर हम वहां पर डिले कर गए तो कोर्ट वोंट एंटरटेन. बट अगर हमारे पास कोई एग्जेम्पशन है, नाउ एग्जेम्पशन इज अवेलेबल इन लिमिटेशन एक्ट. It would be too much for you people now to, I will ask you to go to Limitation Act and all those acts. So, but you just need to understand that Limitation Act covers exemption as well as time limitation. Exemption could be for any purpose, either for not having knowledge, for committing any fraud, then those strict limitation period are relaxed. But you need to mention in the court, in your pleadings specifically, that why should you get those exemption. Order 7, Rule 6 says grounds of exemption from limitation law. I'm contesting a case on the very same issue. Here, now it is a second appeal, regular second appeal pending before the Honorable Delhi High Court. In that case, what happened? My client was terminated from services. I, rather than going in writ petition, filed a suit of declaration that my client's removal from the job was illegal and he should be reinstated. But what happened? My client was removed from the job. He was employed in a bank in 2012. And he received communication order of his removal on 6th of November 2012. After that, I filed the suit in 2015 on 5th of November. 5th of November 2015, I filed the suit. But what happened, although not I, but my client filed the suit because someone else was lawyer at that time. What happened, that order was dated 1st of November 2012, but that was received. I received that order on 6th of November 2012. And suit was filed on 5th of November 2015. Defendant came in the court and defendant argued that this suit was filed beyond 3 years. Beyond 3 years, so as per Limitation Act, it is barred because it is a suit for declaration and they should have filed within 3 years only. Now, I had to mention, my client had to mention in the suit that he received copy of the removal order on 6th of November 2012. He should have mentioned this fact in the plaint. Had he mentioned that fact in the plaint, then court would have assumed that cause of action actually begins from knowledge, which is 6th of November 2012, and not the date of order, which is 1st of November 2012. So ultimately, this fact was not mentioned in the plaint, though suit was dismissed against my client. And then I went in appeal. It is pending before Honorable Delhi High Court. We are arguing on different points, but ultimately, it costs you much if you don't state exemption ground in your pleadings. Once you are not stating, court will say that you can't take its benefit now because you should have mentioned in your pleadings first time. So after order 7, rule 6 comes relief to be specifically stated. Every plaint shall state specifically the relief which the plaintiff claims, either simply or in the alternative. And it shall not be necessary to ask for general or other relief, which may always be given as the court may think just to same extent. So now coming to the prayer part again. Relief here means prayer. It should be specifically stated as I stated earlier. Therefore, you can read our prayer. Here A states, prayer A, decree for possession in favor of plaintiff. So in favor of plaintiff is also necessary. In mere favor mein karo. And against the defendant, this part is also necessary. Thereby directing the defendants to hand over the peaceful and vacant possession of the suit property in question, bearing shop number. So stating exact address of shop number is also necessary. Then after that also, we have ensured more specifically shown in red color in the site plan. So there should be no confusion in anyone's head that we are talking of some other property, or we might be referring to some other neighboring property or anything. It is clearly mentioned that what property I am asking for. This is what order 7, rule 7 asks for. Then after that, pass a decree for recovery. Again, I have specifically asked that this much amount I am asking for and this much of this much period I want it. Order 7, rule 8 says where the plaintiff seeks relief in respect of several distinct claims or causes of action. founded upon separate and distinct ground, they shall be stated as far as may be separately or distinctly. So हमने इसके अंदर घर खाली करने के लिए भी बोला है, हमने हमारा किराया लेने के लिए भी बोला है, तो हमने सारे अपने ग्राउंड्स को स्पेसिफिकली तो प्रेयर्स को अलग अलग मेंशन किया है. पैसों की प्रेयर अलग है, घर खाली करने की प्रेयर अलग है. After that comes, all these things are complied in proper manner. Order 7 says, where the court orders the summons be served on the defendant in the manner provided in the Rule 9, Order 5, it will direct plaintiff to present as many copies of the plaint on plain paper as there are defendants within 7 days. So, after we comply with all these things, we submit our plaint in the court to take further appropriate action against the defendant and call the defendant in the court to answer my claim which we have raised in the suit, and court orders for the supply of the copy to the defendant as per Order 7 Rule 9. Order 7 Rule 10 says return of the plaint. अगर मैं इसमें से कोई भी चीज कंप्लाई नहीं कर रहा हूं जो मैंने आपको स्ट्रिक्टली एक्सप्लेन करी है, Order 7 Rule 10 says suit be returned to be presented to the court to which the suit should have been instituted. अब इसके अंदर मैंने 30,000 के अंदर सूट फाइल किया था क्योंकि ये जिस उत्तम नगर का मैटर था 2014 में 30,000 के अंदर लगता था. अगर इसका टेरिटोरियल जुरिसडिक्शन 30,000 ही था और मैं उस टाइम पे साकेत में फाइल कर देता, तो कोर्ट ऑर्डर 7 रूल 10 में मुझे कहता कि भाई ये प्लेंट वापस ले लो, ये प्लेंट यहाँ एंटरटेन नहीं हो सकती है, आप इसको अप्रोप्रिएट 30,000 कोर्ट के जुरिसडिक्शन में फाइल करो. आज की तारीख में द्वारका में फाइल होगा ये केस, लेकिन उस टाइम पे 30,000 ही अप्रोप्रिएट टेरिटोरियल जुरिसडिक्शन था. आपको सेक्शन 20 पढ़ना होगा कोड ऑफ सिविल प्रोसीजर का टू अंडरस्टैंड जुरिसडिक्शन एस्पेक्ट. इट इज अनदर सिग्निफिकेंट थिंग बिकॉज आप अपनी प्लेंट के अंदर मेंशन करते हो कॉज ऑफ एक्शन के साथ साथ जुरिसडिक्शन भी, जुरिसडिक्शन एंड देन वैल्यू. तो ये तीन चीजें बहुत सिग्निफिकेंट होती हैं क्योंकि अगर आपका टेरिटोरियल जुरिसडिक्शन करेक्ट नहीं है तो वहां पर जो डिक्री पास होगी उसकी एग्जीक्यूशन नहीं हो पाएगी अल्टीमेटली, क्योंकि वहां और सामने वाली पार्टी भी आके कोर्ट में यही ऑब्जेक्शन लेगी कि इसका प्रॉपर जुरिसडिक्शन नहीं है, आप इस प्लेंट को वापस करो. सो अल्टीमेटली आपका पूरी मेहनत बेकार जानी है. ऑर्डर 7 रूल 11 बहुत इंपॉर्टेंट प्रोविजन है, बहुत बार यूज होता है, लेकिन ड्राफ्टिंग प्लीडिंग के पर्पस के लिए भी उस पर डिस्कस करना बेकार है क्योंकि वो एक पूरा एक क्लास का टॉपिक है. बट आप ऑर्डर 7 रूल 11 पढ़िएगा जरूर. इट इज रिजेक्शन ऑफ प्लेंट. जनरली इन एवरी सिविल प्रोसीडिंग वी विटनेस द डिफेंडेंट इज कमिंग टू द कोर्ट. जब भी ये सूट फाइल होता है, डिफेंडेंट कोर्ट में आता है, अपने रिप्लाई के साथ साथ एक एप्लीकेशन जरूर फाइल करता है 711 की, ये सूट डिसमिस करो. और 711 के अंदर डिसमिस करने के मोटे मोटे 5 ग्राउंड है, जिसके अंदर सबसे इंपॉर्टेंट है जहां पे कॉज ऑफ एक्शन नहीं है. अगर आपके मटेरियल फैक्ट्स आप ठीक से ड्राफ्ट नहीं कर रहे हो, अगर आप उसके अंदर प्रेयर ठीक से ड्राफ्ट नहीं कर रहे हो, अगर आप उसके अंदर स्पेसिफाई नहीं कर रहे हो कि आपकी ग्रीवांस क्या है, वो सूट डिसमिस हो जाएगा फॉर कॉज ऑफ एक्शन, एब्सेंस ऑफ कॉज ऑफ एक्शन. जहां पे आपने अपना रिलीफ अंडर वैल्यू किया है, मैंने आपको ऑलरेडी एक्सप्लेन किया कि 3 लाख तक सूट कहाँ जाता है, 20 लाख तक कहाँ जाता है, 2 करोड़ तक कहाँ जाता है. और अगर आपने इस चीज को कंसील किया, हाइड किया, कोर्ट फी अवॉइड करने के लिए, आपने अगर अपने सूट को अंडर वैल्यू किया है, तो कोर्ट आपको बोलेगा कि इसकी वैल्यूएशन ये गलत है, इसकी करेक्ट वैल्यूएशन ये है और आपको इतने रुपए पे करने हैं. अगर आप पे नहीं करोगे तो आपका सूट डिसमिस हो जाएगा, बट कोर्ट आपको अपॉर्चुनिटी देगा. यहाँ पर हमने फाइल किया है 12,000 रुपए हर मंथ के हिसाब से लीगल पोजीशन का, 8 महीने का किराया हो गया 500 रुपए के हिसाब से 2013 तक 12% पर एनम. तो मुझे इसकी कोर्ट फी देनी होगी टोटल कंप्यूटेशन करके. कोर्ट फी जनरली 3% टू 4% वेरी करती है, 3% टू 4% होती है ऑफ द टोटल क्लेम. लोग उस 3 से 4% कोर्ट फी देने को अवॉइड करने के लिए अपने अपने सूट को अंडर वैल्यू करते हैं कि भाई नहीं, इसमें उतना ही रुपया लग रहा है, इसके अंदर तो इतने रुपए ही खर्च होंगे. तो इस चीज को अवॉइड करोगे तो डिफेंडेंट आके ऑब्जेक्शन रेज करेगा और कोर्ट बोलेगा कि आपने अप्रोप्रिएटली वैल्यू नहीं किया, आप इसको वैल्यू करो, इतने रुपए जमा कराओ, अदरवाइज सूट डिसमिस हो जाता है. ऑप्शन सी ऑर्डर 11 रूल सी, ऑर्डर 7 रूल 11 सब रूल सी. where the relief claimed is properly valued, plaintiff is written upon a paper insufficiently stamped. So कोर्ट फी देनी होती है, उसके साथ ही आपको स्टाम्प भी लगता है इस पे, वो आपको प्रॉपर्ली पे करना होता है. And then where the suit, D is the most important, where the suit appears from the statement in the plain to be barred by any law. आप MCD है, MCD का सेपरेट एक्ट कॉन्स्टिट्यूट हो रखा है, या फिर आप लोगों का लोन का केस है जहाँ पे हो सकता है DRT का जुरिस्डिक्शन हो, और MCD के अंदर MCD ट्रिब्यूनल का जुरिस्डिक्शन होता है. उन पर्टिकुलर एरियाज को लेके अगर आप सूट फाइल कर देते हो, सिविल सूट, वहां पर अगर आप कोई रिलीफ लेने के लिए आ जाते हो, तो ऑर्डर 7 रूल 11D ये कहता है कि जहां पे एक्ट किसी और एक्ट में स्पेसिफिकली लिखा है कि सिविल कोर्ट का जुरिस्डिक्शन नहीं है, इट मींस दैट सूट विल बी डिसमिस्ड अंडर ऑर्डर 7 रूल 11, बिकॉज सिविल कोर्ट के पास पावर नहीं है उस पर्टिकुलर सूट को सुनने की. सरफेसी एक्ट के अंदर सेक्शन 34 है, वो कहता है कि कोई पावर अगर DRT के पास है ग्रांट करने की, तो उस पर्टिकुलर मैटर के अंदर कोई भी सूट एंटरटेन नहीं हो सकता है. तो अगर कोई भी केस फाइल करता है बैंक लोन अवॉइड करने के लिए इन द सिविल सूट, देन कोर्ट वोंट एंटरटेन दैट, it would be barred by law under order 7 rule 11D, and then that plaint will be rejected. This is what people sometimes try to do to avoid rigors of law in the DRT and ultimately to prolong the proceedings. Once 711 is also done, come to order 8. I won't share, you can read other rules of the order 7. I am only strictly dealing with the significant aspect of pleadings only. Order 8 is written statement. Written statement is what happens after suit is admitted, notice is issued to the defendant, and then the defendant appears in the court and seeks permission to file the written statement. Order 8, Rule 1, written statement, it states that defendant shall within 30 days from the date of service of summons on him present a written statement of his defense. So जब प्लेंट कोर्ट में चली गई, नोटिस इशू हो गया, समन पहुंचने के बाद विदिन 30 डेज आपको कोर्ट में आपका रिप्लाई देना है. इट इज नॉट strict, because if you can't file within 30 days, then you will be given another 60 days, but with the permission of the breach करने का right खत्म हो जाएगा. Now, what is written statement? स्वाति इसके अंदर पेज नंबर, एक मिनट में बताता हूँ. (66) of the PDF.
This fine?
Yes, yes. So you people can see written statement on behalf of respondent Bhagwan Devi in this case. Written statement as per order 8, rule 1 we said, already read, that it should be filed within 30 days after receipt of the summons. Rule 2 states new facts must be especially pleaded. Defendant must show जो order 8 rule 2 कहता है, new facts must be specially pleaded. So these are new facts which was not mentioned in the suit, but it is mentioned in the written statement. So these are called new facts, and which shows that the suit is barred. Now see, what is preliminary objection number 1? That the suit by the plaintiff is not maintainable and is liable to be dismissed in view of section 3C of Delhi Rent Control Act. They are saying that this suit is barred. So जो 711 की मैंने बात करी थी आपको, वो उन्होंने रिटन स्टेटमेंट में भी लिखा है कि केस ऑफ द प्लेंटिफ दैट द मंथली रेंट ऑफ द शॉप इज इन क्वेश्चन इज ₹500 पर मंथ. आप लोग अगर दिल्ली रेंट कंट्रोल एक्ट पढ़ोगे आपको पता चलेगा दैट 3500 तक का किराया दिल्ली रेंट कंट्रोल एक्ट एप्लीकेबल होता है. उसके बाद अगर किराया 3500 से ऊपर है तो आपका मैटर एविक्शन के लिए सिविल सूट में जाएगा. सो हेयर डिफेंडेंट सेड कि 500 रुपए किराया मेरे तो दिल्ली रेंट कंट्रोल एक्ट के अंदर बनता है. तो इन्होंने सबसे पहले मेंशन कर दिया ये एज अ प्रिलिमिनरी ऑब्जेक्शन एज पर ऑर्डर 8 रूल 2. Then second defense they have taken, respondent number 2 has no concern with the answering respondent as he has been doing the repair work of cycle and rickshaw on the footpath. So respondent number 2 irrelevant party है. Again coming to order 1 rule 10 part, जो मैंने कहा था कि अगर irrelevant party को आप member बनाओ, वो defendant बनाओगे, तो ultimately we will have to face the consequences. Here defendant submitted, respondent number 2 is irrelevant party. They should have written defendant number 2, but leave it aside. Third objection is that answering respondent is ready and willing to make the payment of ₹500 per month to the plaintiff. However, the plaintiff has not been receiving the same. So basically, मैंने कभी किराया देने से मना नहीं किया, मैं किराया आज भी देने के लिए ready हूँ. This is what defendant submitted, and suit is liable to be dismissed for misjoinder and non-joinder of necessary parties. Now here comes that order 1 part which I shared in memo of parties. that की necessary parties इसके अंदर नहीं बनी है because suit property was owned by late Shri Jeet Ram and उनके 2 बेटे थे, एक बेटी थी, और legal heirs of Jeet Ram and all the legal heirs necessary proper parties. Son of the defendant Lakshmi Kumar is running the sad shop. So इन्होंने ना तो डिफेंडेंट के बेटे को पार्टी बनाया है जो कि वहां पे शॉप रन कर रहा है, और ना प्लेंटिफ खुद सोल ओनर नहीं है. प्लेंटिफ के साथ उसके और 2 बेटे हैं, वो भी ओनर है प्रॉपर्टी के, उनको भी पार्टी बनना चाहिए था. सो दिस इज द 4th ऑब्जेक्शन. सो एज पर ऑर्डर 8 रूल 2 इन्होंने पूरे जो प्रिलिमिनरी ऑब्जेक्शन होते हैं उसमें नए फैक्ट्स जो भी मेंशन करना चाहते हो वो कर दिए. नाउ रिप्लाई ऑन मेरिट्स. Reply on merits is very important portion of the written statement because each and every paragraph of the plaint should be denied specifically in the written statement. If you will see order 8 rule 3, it says denial to be specific. It shall not be sufficient for a defendant in his written statement to deny generally the grounds alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth except damages. So order 8 rule 3 is very clear कि आप general evasive denial नहीं कर सकते हो कि in everything of the plaint is denied in general terms. But उन्होंने अगर कहा है कि मैं ओनर हूँ उस प्रॉपर्टी की, तो आपने रिप्लाई में लिखोगे नो यू आर नॉट द ओनर but falana other person is owner of the property. So here in this case, if you can see, they have prepared very casual written statement. Paragraph number 1 and 2 are denied. The contents of paragraph 1 or 2 the plaint are matter of record and same requires strict scrutiny. So they have not denied it. Then paragraph number 3 and 4, the contents of paragraph 3 and 4 of the plaint are admitted to the extent of rent of 500 per month. However, the site plan annexed by the plaintiff has not been properly drafted, which is wrong and denied. Now, if you observe this paragraph carefully, you will notice that defendant has admitted himself to be tenant. तो अब defendant इस केस के अंदर ये नहीं कह सकता that I am owner of the property or plaintiff is not the owner but I am the owner of the property. Defendant cannot take this plea because he has admitted that 500 rupees is rent. So he has admitted that he is tenant. और site plan का इन्होंने objection किया because it is not properly drafted. After that, they have admitted paragraph number 5. The content of paragraph number 5 of the plaint are true and admitted. Contents of paragraph number 6 are all admitted and the content paragraph 7 of denied because the name of the plaintiff has been added later. So these are vague denials. Coming to the order 8 rule 4, again which is of evasive denial. Where a defendant denies an allegation of fact in the plaint, he must not do so evasively but answer the point of substance. Thus, if it is alleged that he received certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any part thereof, or else set out how much he received. And if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. So आपको अगर मैंने बोला कि आपने 50,000 रुपए लिए हैं और आप लिख रहे हो कि मैंने हर्ष से कोई पैसे नहीं लिए हैं, इट वोंट बी सफिशिएंट. आपको लिखना होगा कि मैंने कोई भी 50,000 रुपए इतनी तारीख को जो एलिगेशन लगाया गया है कभी नहीं लिए. आपको स्पेसिफिक डिनायल करना होगा. इवेसिव डिनायल करोगे तो कोर्ट विल से दैट यू हैव एडमिटेड दैट आई हैव गिवन यू 50,000 रुपीज. So this is what is rule 4, and rule 5 is also on the same line, which is specific denial and evasive denial. Order 8, rule 6 is set off in the written statement. Set off is generally मैंने आपको 50,000 दिया, आपने मेरे को 25,000 दे रखे हैं या फिर 50,000 ही दे रखे हैं ऑलरेडी, तो आप कहोगे कि भाई मैंने आपको 50,000 दिए तो उससे पहले आपने मेरे को 50,000 दे रखे थे, तो उन दोनों पैसों को एडजस्ट कर लो. But this plea needs to be taken in your written statement. If you don't take this plea in your written statement, then you can't claim it later. It is order 8, rule 6. एंड देन उसके बाद आप आफ्टर कंप्लीट डिनायल आती है, इसमें लास्ट में जाना है एक बार रिटर्न स्टेटमेंट के, आप उनकी प्रेयर को डिनाई करते हो. आफ्टर डिनाइंग एवरी पैराग्राफ स्पेसिफिकली आप ये कहते हो, इट इज देयरफॉर मोस्ट प्लेडेड ऑनरेबल कोर्ट में काइंडली बी प्लीज टू डिसमिस द सूट ऑफ द प्लेंटिफ कीपिंग इन व्यू द फैक्ट्स एंड सर्कमस्टेंसेस ऑफ द मेंशन्ड बिलो. अगेन प्रेयर ऑफ द डिफेंडेंट इज आल्सो इंपॉर्टेंट. नाउ defendant files written statement within 30 days or 90 days after permission of the court, and after seeing those two pleadings, court ultimately decide on basis of these two pleadings that what are issues between the parties. Court checks that if parties are fighting over any fact. In this case, court found out that there is no dispute on the fact that the Kamlesh Devi is landlord and this defendant lady is agreeing and admitting herself to be tenant. Once this fact is admitted, there is no requirement to frame issue in regard to this fact. Only issue was framed in regard to the pendency of the rent, which was 500 rupees earlier and subsequently 12,000 was asked. So court ultimately, on the basis of order 12 rule 6, passed decree of eviction in this case against the defendant, because defendant admitted herself to be tenant and she also admitted that she received notice of the plaintiff landlord to evict the property. Once these two facts are admitted, court says that you have no reason to stay in the property. And these two facts were admitted in the written statement. So it was fatal error from the side of defendant to admit these two things in the written statement, that she is tenant and also the fact that she has received the eviction notice. The moment she accepted in response to the plaint, then there was nothing left to give evidence. There was nothing left to prepare issue between the parties. क्योंकि कोर्ट में आपने एडमिट कर लिया है अपना केस. Similarly, this is generally in very brief suits. There is also another petition which I want to show you in very short span of time. I will try to show this to you. तो आप एक बार ये भी शेयर कर देना, मैंने आपको भेजा है.
Jodhpur petition file, right?
Writ petition.
Yeah. Sharing the screen in a second.
this is earlier we dealt with civil suit, and code of civil procedure deals with civil suits, appeals, and similar proceedings like written statement and related proceedings. Writ petition is again quite vast area, where under Article 226 as well as under Article 32, we directly approach Honorable High Court or Honorable Supreme Court, taking our grievances. You must already be knowing that what are grounds wherein we approach high courts and Supreme Court. Generally, we go to High Court because of violation of fundamental right or legal right. We go to Supreme Court because of violation of fundamental right. So this is writ petition where I approached High Court because of violation of legal right of my client company petitioner herein, and I alleged several things. Now, most of the thing which is important to notice in writ petitions is, again, principle is same, that you have to state material facts, and then you have to state that when cause of action arose, and then you have to mention your prayer. Again, in writ petition, there is no limitation period, but Supreme Court repeatedly says principle of limitation, which is applicable on civil suits, are applicable on writ petition as well. So it is applicable on writ petition in spirit. Court might say that you have approached High Court with too much delay. There is no time limit mentioned in any act, but you have approached court with too much delay. Court might refuse you any relief. So people should be mindful of limitation in writ petition as well, though it is not stated anywhere. Coming to the facts, it comprises of synopsis, which is visible on your screen. And after synopsis, Swati, आगे चलो इसमें. Synopsis is brief of the facts. Generally, High Court judges and Supreme Court judges don't have time to go through your petition thoroughly. So synopsis should be carefully drafted. No synopsis should be more than 4 pages. If you in future you will give AOR examination and related, you will draft plethora number of petitions, you will realize that crux of the case, point of the case, should be specifically called out in your synopsis, because judges sitting there get time to read only and only synopsis. They don't go in your petition, in your annexures thoroughly, like civil judges do in civil courts. They get time, but in High Court, Supreme Court, you don't get this time. You have to satisfy your case from synopsis only, and then you will get further hearing. This is the index portion, so इसको आगे बढ़ो, स्वाति. आगे 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 और आगे. Now this is ऊपर 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 करो. This is title of the writ petition. Firstly, I have addressed to the respective court. सबसे इसके ऊपर स्वाति. As I have mentioned in civil suit, memo of parties. So in writ petition, it goes like this. It varies slightly in different courts. It is from Rajasthan. In Delhi also, it generally goes like this. But in Allahabad High Court, it's a bit different. So this is how it goes. You mentioned memo of parties kind of information in regard to both parties. After that, we go on further. आगे बढ़ना स्वाति इसमें. We need to mention that why have we approached court. So this is what I am mentioning. ऊपर 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 सबसे पहला इसमें जो बोल्ड में है. हाँ. Civil writ petition under 226 and in the matter of articles 14, 16 and 21 of Constitution of India. So I have stated that what particular articles of the Constitution have been violated. This is why I have appeared before the High Court in article 226. Going further, आगे बढ़ना स्वाति. I have also mentioned that there is in the matter of MSMED Act इसके अंदर involved है, and Arbitration Conciliation Act का भी involvement है. और उसके बाद जो इसके अंदर इंपॉर्टेंट एक्ट और रूल्स मेंशन्ड है वो सब भी टाइटल के अंदर आ जाते हैं. गोइंग फर्दर, आप उसके अंदर मेंशन करते हो दैट विच पर्टिकुलर ऑर्डर यू आर अग्रीड विद. इसके ऊपर है जस्टिस के ऊपर. I have mentioned in the matter of illegal consideration of the respondent number 1 claim by the respondent number 2 for denial of opportunity to the petitioner company to represent and for improper application of the Arbitration and Conciliation Act with various orders impugned herein prominently by order of the proceeding dated 14th of September 2021. I have mentioned that I am agreed with these orders and it has violated my legal right, and these act or this particular act has been violated in the impugned proceedings. उसके बाद going further, इसके नीचे जाओ स्वाति, आप एड्रेस करते हो टू ऑनरेबल चीफ जस्टिस एंड लॉर्डशिप, आगे चलो, आगे आगे आगे. Then you start with facts in detail that this is the petitioner company. Then you brief facts giving rise to the instant writ petition that the petitioner, नीचे 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 चलती रहो, इसमें जरा टाइम देंगे तो फिर और बहुत जरा टाइम लग जाएगा. ये इसके अंदर brief facts हैं to explain to the court that what was actually the case. Judges don't read it. I am again repeatedly telling you, they don't get time to read this. They might read, but it's very tough. You will have to take them to relevant paragraphs that this is the relevant pleading, but you have to mention each and every fact carefully in the writ petition, as I have shared with all the annexures. And annexures you can see in bold, annexure 13, 14, and these facts. चलती रहो इसमें, चलती रहो, थोड़ा बड़ी writ petition है. Then रुको रुको रुको. Then comes ground portion. After stating your facts, you mention grounds. Grounds should be legal ground, and those grounds are very important because if grounds are not there, then judges might not entertain it, and you will have to satisfy them that these. Did someone say anything?
No, I just after it. You can continue.
So you need to specify grounds on which you people or petitioner is relying upon. I have mentioned because the action of the respondent is highly illegal, arbitrary, without jurisdiction as such, humble petition institution requires. Then I have also mentioned that because contract awarded to petitioner herein by the Rajcom BDA order rated this and this was admittedly for the work contract, there is no direction or involvement of the respondent number one. आगे. Then I have also mentioned case law. I earlier told you that we should refrain to mention law. We should always careful about facts. In fact, there is very famous saying by Nani Palkhiwala that a lawyer can afford to commit mistake on law, but a lawyer cannot afford to commit mistake on fact. Here, our facts should be very clear on which we are relying upon, and it is not necessary to state law. Towards keeping precautionary side ahead, mention these case laws because in this particular writ petition, there was direct violation of certain judgments of the courts. So this is why I in bold mentioned citation and name of those relevant cases, but otherwise it need not be. It is not that necessary unless there is direct violation of any particular direction or judgment of the Supreme Court. Only then you can mention, otherwise avoid it. Because stating law in your pleadings is not necessary aspect or necessity. Going further, Swati, इसमें आगे चलो. Like civil suits only, you mention your grounds. आगे आगे चलती रहो, इसमें सारे grounds हैं. Wait. तो इसके ऊपर चलना एक बार और ऊपर. तो S till P Q R हो गया, R के बाद S है. S तक इसके अंदर S T तक इसके अंदर ग्राउंड्स चल रहे हैं. माय फॉर्मर सीनियर यूज्ड टू टेल मी कि जब तक Z तक आप ना पहुंचो तब तक आपकी रिट पिटिशन कंप्लीट नहीं हुई है. सो यू शुड एटलीस्ट कैरी 26 लीगल ग्राउंड्स for approaching high court. Only then you will be able to justify. That is different matter. People sometimes add too many irrelevant grounds as well. But yes, you should have legal grounds before approaching high court. इसके बाद अगेन सिमिलर टू सूट कम्स प्रेयर. Here prayer portion again should be carefully drafted. Instant petition for writ may kindly be ordered to be allowed, or appropriate nature may kindly be issued in favor of the humble petitioner. फिर उसके बाद impugn order dated. It's necessary to mention very clearly that what particular order you are asking to set aside may kindly be suitably quashed and set aside. Then there is third, proceeding before Micro and Small Enterprises Facilitation Council be set aside. Then going further, any other. So this prayer number 4, any other order which this court may deems fit and proper. एक बार एक केस हुआ था जिसके अंदर अल्टीमेटली आर्ग्यूमेंट्स वर स्टक ऑन द पॉइंट कि आपने तो ये प्रेयर मांगी ही नहीं है. So lawyer very carefully argued, because it's in formal manner, it is generally written last. Any other order which this honorable court may deem fit and proper. So that lawyer carefully argued that even though I not wrote specifically, but this my prayer can be granted in prayer number 4, which I have shared. Any other order which this court may deem fit and proper in the fact and circumstances of the case. So it's quite general, but actually it should be avoided, and your every relief must be specifically mentioned in your prayer clause. And generally it depends from case to case, discretion of the High Court. Court may not ask for reply or counter from the respondent, unlike written statement. Written statement is right of the defendant, and written statement is mentioned in CPC. It should be filed, but there is no requirement of counter or reply of the writ petition. It is not the necessity. So court is generally grants order or ultimately judgment on the basis of only petition. I guess it would be sufficient for today, because although there are so many other drafts as well, I did not intend to take so much time. Swati,
Yes, sure. Okay. So, anyone has any questions they can ask right now? Any student has any query, they can raise their hands and ask questions to the resource person. I don't
सर
see any.
yes.
सर मेरा एक क्वेश्चन था कि सर अगर सिविल मैटर और क्रिमिनल मैटर साथ में है तो फिर उसमें क्या रहता है?
सिविल मैटर और क्रिमिनल मैटर साथ में है मतलब कैसे? जैसे कि मान लो 420 का एक एफआईआर हो गया कि, और साथ साथ आपने सिविल सूट फाइल कर दिया रिकवरी का.
जैसे मान लो सर पैसे का ही मैटर चल रहा है, उसी में किसी ने पैसे नहीं दिए तो आउट ऑफ फ्रस्ट्रेशन जब केस चल रहा है
हाँ.
तब हर्ट के चार्जेस लग गए, ग्रीवियस हर्ट के चार्जेस लग गए आउटसाइड द कोर्ट, जो कि रिलेटेड टू दिस मैटर है
अच्छा,
कि
मतलब आप
पैसे नहीं,
कह रहे हो कि हमारे पैसों का लेन देन था, उस पर रिकवरी सूट चल रहा है, फिर उसके बाद मारा पीटी हो गई.
उसके चलते हुए ही हो गई मारा पिटी, तो फिर जिसको जिसको मतलब जिसको पैसे देने हैं ना डिफेंडेंट को, वो कह
हाँ.
रहा है कि मेरे साथ तो मारा पिटी हो गई, तो
हाँ.
फिर मैं मतलब ये तो गलत है कि ये तो पैसे नहीं दूंगा मैं ऐसे अब।
बिल्कुल नहीं, ऐसा नहीं है. देखो, बोथ थिंग्स आर डिसाइडेड सेपरेटली ऑन द एडमिटेड लीगल प्रिंसिपल्स. वंस आपने सिविल सूट फाइल किया है फॉर द रिकवरी, तो कोर्ट उसके अंदर एविडेंसेस से ये देखेगा कि भाई आपके पास क्या एविडेंस है टू शो दैट यू हैड टेंडर्ड दिस मच अमाउंट टू द डिफेंडेंट. तभी तो आप उसका पैसा मांग रहे हो. और आपने वो डिफेंडेंट को कब दिया, कैसे दिया, वो आप एविडेंसेस दोगे, वो एविडेंसेस प्रूव होंगे. उसके बाद आपके साथ किसके साथ मारापीटी हुई है, मारापीटी नहीं हुई है, दैट इज मैटर ऑफ क्रिमिनल कोर्ट. वहां पे किसी को अगर लगी है, किसी की सीरियस लगी है, तो ग्रीवियस हर्ट होगा जो भी होगा, वो क्रिमिनल कोर्ट डिसाइड करेगा. उसके अंदर ये फैक्ट रेलिवेंट नहीं है सिविल केस के अंदर कि आपके साथ मारापीटी हो गई तो पैसे नहीं मिलेंगे. ऐसा नहीं होता है. each and every case is decided on the basis of principle relevant to those proceedings and evidence present in those proceedings. उसके अलावा बाहर क्या हो रहा है, किसके साथ कैसे हो रहा है, it won't be taken into account. Himanshu,
ओके सर
if you want to ask anything else, you can ask.
नो सर.
Anyone else has any other query?
Himanshu has
Yes.
asked.
I can, yeah.
Good evening, sir.
Good evening.
Sir, if there is a suit for eviction and there are two joint owners and they had to file a suit and one is interested and another is not interested, then
One can file because see, tenant, if tenant takes this plea, tenants do take this plea that all owners have not come to the court to evict me. Court says it is not concern of tenant.
sir, my question is different. I'm saying that there are two joint owners of the same property and one is both are necessary party, one is interested and another is not interested.
Both are not necessary party. This is what I'm telling you. In eviction suit, only one interested party is good enough to file the suit. Both are not necessary party. Both are owners. Both are necessary to sell the property if they have to sell the property.
If
But
someone wants to make them one necessary party to be a defendant, is there a chance?
tenants do take this plea that other party should also be here to contest the suit. But court say that you are not concerned with that. You should not be concerned with that. If one joint owner is asking for your eviction, it is good enough. बहुत इस पे बहुत केस लो भी मिल जाएंगे. Astha, I guess, is asking something.
Yes, sir. Good evening, sir. Sir, my question is that if anything happened like in middle of the state, the petitioner died, then
Yes, so then you can arrange in their legal years. अगर किसी की डेथ होती है तो ऑर्डर 23 is relevant and order 22, not 23. Order 22 says that if defendant or plaintiff, if anyone passes away or dies, then legal year of that relevant party comes on record and then they prosecute the case, subject to the fact that cause of action should survive. Suppose you are filing, contesting a case which is related to me only, suppose defamation. If defamation, I have filed defamation suit against someone, meanwhile I die and pass away, then ultimately whether my legal heirs have a right to run this case, whether my legal heirs can claim that my reputation was also related to their reputation. So that particular fact is dependent upon that, but legal heirs can be arraigned even if party passes away during the pendency of the case. In criminal cases, proceedings abate. That is different matter. Because you have no one to punish now.
thank you, sir.
ललिता का केस बहुत फेमस है इस रिगार्ड में.
Okay, sir. Thank you, sir.
Any other question? I think no one has raised a hand. So I would like to conclude the lecture by thanking you, sir, on behalf of Fairfield Institute of Management and Technology, School of Law. I express my sincerest gratitude that you took out time from your schedule and delivered such an insightful lecture. The way you explained in an articulate manner the civil writ petitions and civil proceedings, I'm sure it must have greatly helped our students. Thank you so much, sir, on behalf of all the students and School of Law.
Thank you. It was nice to be here. I hope
Same
to
here, sir.
again.
Thank you so much, sir. Students, I will be sharing the feedback form. You can fill it and submit it. Okay. There are some messages. Thank you.